Good afternoon, Mr. Laing.
Good afternoon, Acting Chief Justice.
Did I pronounce your surname correctly?
Yes.
Is it Laing or Laing?
Laing, but
Laing.
as you pronounced it.
Oh, okay, all right. Welcome to this session of the interviews, and thank you for making yourself available for consideration for appointment as a judge of the Eastern Cape Division of the High Court.
Thank you, Acting Chief Justice. It's a real honor to be here.
Yes. I see that you hold quite a few degrees. You got a BA degree in 1992, and you got that was from the University of Cape Town. Is that right?
Yes, that's correct.
And you got your LLB from the same university in 1994.
Yes.
And you then did a BA honors and obtained it from UNISA in 2002.
That's correct, yes.
And you got your LLM from the University of Nottingham in 2012.
Yes, Acting Chief Justice.
Yes. And you are a director in a firm called Clark Laing Incorporated. That's your firm.
That's my firm.
Yes. Prior to your firm, did you practice earlier than that in another firm?
Yes, I practiced previously at a firm called Smith Tabata Incorporated.
Yes.
Also in East London.
Yes.
And that was for a period of 16 years.
Over 16 years?
16 years.
Yes. Okay. And you continue to practice in your firm at the moment?
I do, Acting Chief Justice.
So all in all, you have been in practice for about 25 years?
I think about 24 years, well, post-qualification experience. So I was admitted in 1997.
Yeah.
So that it would take me to about 24 years.
Yes. Okay. In your practice and before you had your own law firm, did you do trial work in which you conducted the trials yourself in the courts, or did you not get involved? You'd always just be the instructing attorney and you brief counsel?
No, I was privileged to have been able to conduct trials, both civil and criminal trials, during my period of articles. And that was a mix of as I say, civil and criminal trials, but also with opposed applications and the usual motion court activities. And that period of my professional life fell over my articles and extended some way into my years as a junior associate when at Smith Tabata.
So you only did trials yourself, either when you were serving your articles or soon after your admission, those years when you were junior attorney?
Yes, Acting Chief Justice. Those trials I did myself.
Yeah.
And dealt with them directly.
Yes.
But then progressively, as I gained experience in high court litigation, I preferred working in a team, and that's when I would brief counsel.
Yeah.
To work on trials.
Yes. So you were involved in trials, but only as an instructing attorney after that stage?
Yes.
Yes. And did they involve criminal and civil trials, or mainly, or only civil trials at that level?
No, again, a mix of civil and criminal trials.
Yes.
I will admit not many, My work has involved mainly opposed applications and that type of thing. But certainly, I have been involved in both criminal and civil trials with counsel previously.
And does your practice have a lot of motion court work?
Yes, Acting Chief Justice, a fair amount. We're relatively young and a relatively small practice, so maybe not quite as much as what we would like, but I'm sure as we grow, that particular area will expand as well.
And what branches of law has your practice exposed you to? When I say your practice, including before you had your own law firm?
Predominantly administrative law. That's really my main area of work, with a particular interest in public procurement issues. But in addition to that, I have had exposure to contract law, a little bit of commercial law. Constitutional law, of course, informs most of if all the areas of law. But certainly by far the majority of my work has been in the field of administrative law.
And you have also acted in the High Court?
Yes, I have.
For how long have you acted?
I have performed 5 acting stints, and if you add up the sum of the duration of each of them, if I calculated correctly, came to about 23 weeks. But if you add the time spent dealing with part-heard matters, I think it takes it closer to about 35 weeks.
Yes. And how did you enjoy acting?
Very much, thank you. It was a real honor to have been asked to act, and I found it immensely satisfying.
Yes.
I think at some stage the penny dropped, as it were, and I realized that this is what I wanted to do, and this is how I wanted to serve.
Yes.
So it's a deep and a wonderfully meaningful experience. Yes.
Yes. And as an acting judge, how do you find motion courts, particularly motion courts?
I enjoy it. I actually enjoy I suppose I enjoy the activity and the variety that comes through in motion court. There's always something different. There's always something new. The pace at which motion court moves as well has, I suppose, it's taught me to think a lot better on my feet. Not that I've necessarily mastered that, but I particularly enjoy motion court.
Yes. And I see that you have a number of judgments that you have listed in which you were the instructing attorney. Is that right?
Yes.
And they include some that have been reported in the law reports. Is that correct?
Yes, Acting Chief Justice.
Maybe those that have been reported in the usual law reports that I see here, page 16 and 17, are about 3. But are there much more than that?
I think 3 sounds about right.
Yes.
Acting Chief Justice.
Yes. Okay. Judge President.
Thank you, ACJ. Good afternoon, Mr. Laing.
Good afternoon, Judge President.
It behoves me to make disclosures. The first one being that whilst you were at Smith Tabata Incorporated, you briefed me initially as junior to then Advocate Madlanga, now Justice Madlanga. And then upon his elevation to the bench, you continued briefing me even whilst at Smith Tabata. And in fact, after you had set up your own firm, I started receiving work from that firm, from, I would say, colored folks in particular, something I'd never received before. And then I also wish to place it on record that my daughter was a candidate attorney at your firm, and quite recently a professional assistant before he took up another appointment elsewhere. You confirm those two?
Yes, Judge President, I do confirm that.
Then finally, your firm, now your firm, the current firm, previously championed my cause when I sought to recover a debt I had been owed by a recalcitrant lessee. You know that as well.
Yes.
And that was resolved without any form of litigation. In other words, we didn't have to go to court.
No, but that is correct, Judge President.
Thank you. Now, having said all that, you acted more. In fact, your acting stints date as far back as the time when Sangoni JP was JP in the Eastern Cape.
Yes, that is so.
You've got more stints during the Sangoni era than my era. If I look at it, 28 January to 1 March, Eastern Cape, that was prior to my era. 28 July 19 September to 19 September, which was a full term, that was during Sangoni JP's era. 9 October to 27 October, Eastern Cape. That was Judge Sangoni's era as JP. I'm just placing this on the record, basically.
Yes, Judge President.
You've had stints during my era as JP, 2 of them, and they are specified at page 20, the document appearing at page 20. And during that period, you penned 10 judgments in opposed applications, and then 2 judgments in civil trials, 2 criminal trials, 1 criminal appeal, 4 applications for leave to appeal, 1 criminal review, and 1 exception. Would you confirm this information as correct?
Yes, Judge President, I confirm that's correct for the stints post-November 2017.
Independently of what I said about myself, what has your firm done, or how has it contributed towards the transformation agenda? Independently of what I said about myself.
Judge President, if I may answer that, my firm in particular, Clark Laing now, has adopted a practice that was adopted at Smith Tabata when I was there, and that was the practice of briefing mainly black counsel, not exclusively. We do brief white counsel, but predominantly we strive to brief black counsel, and have been fortunate enough to have developed a real appreciation and recognition of the benefits that a diverse range of perspectives and insights bring to a particular legal problem, so that the legal solution that comes through is so much richer and so much ultimately more effective. So that is the approach that we have taken at Clark Laing, and that it simply really comes as a consequence of my experience during my years at Smith Tabata, where the same practice was employed. Again, not exclusively black counsel, but in the main black counsel. And that's the approach that we've attempted to take.
Yes. Would you mention, counsel, that maybe could spring to mind at this forum?
Yes, by name, Judge President?
Yes.
Yes.
I will disclose ultimately. I will make a disclosure as well.
You were briefed. Yes.
Yes. Yes, Commissioner Madonsela, we have an acquaintance previously, but in addition to that, the firm has briefed Advocate. Sorry, this is where my mind starts to go blank. I'm going to need to refer to some of my notes. But certainly while at Smith Tabata, we briefed Advocate Vu and Noche, Advocate Deva Pillay, SC is the late Advocate Deva Pillay, and then a number of the members of the current bench in the Eastern Cape Division, Justice Bloom, Justice Silwa, and then Advocate Amelia de Silva, whom we brief, Clark Laing as well, and Advocate Mapoma is another person. There are a number of black counsel whom we brief. I should perhaps also mention Advocate Jerome Brawns, SC. And then amongst the junior counsel, we have briefed Clark Laing, Advocate Fabian Pretorius, Advocate Devon Young, Advocate Leslie Brawns, Advocate Lucy Berger, Advocate Tingashe Tabata. We've briefed a number, yes.
Thank you. There is what is known as case flow management. Are you familiar with that notion?
Yes, Judge President.
Briefly, what can you share when it comes to that at this forum?
Judge
Or let me say, what is your understanding of case flow management?
My understanding is that it's a mechanism to ensure a more efficient and a more effective administration of justice within the courts. And it allows the court, it allows the judge to intervene at an early stage in the life of a dispute, the life of a matter. From personal experience, I've seen how it reduces the extent of skirmishing or point taking to some degree. And I think that if managed correctly, it certainly does speed up the life of a case and brings it to trial a lot quicker than without case flow management.
Yes. And then there's been reference to the word lucrative work. I'm not sure which association has mentioned that, but I think you did come across that.
Yes.
What I want to know from you, does your firm a recipient of lucrative work? I'm talking to your firm at present.
I'm sorry, Judge President.
Would you say you are recipients of lucrative work? I'm saying this in the context that there was a criticism leveled against you that in spite of the fact that you've got lucrative work, but you have not briefed in keeping with the transformation agenda, something that you've now dealt with, but I want to check whether you've got lucrative work.
Yes.
Because that too must go on record.
Yes. Judge President, we certainly have benefited. We've been very fortunate to have benefited from appointments to panels of a number of municipalities, parastatals, and so on. And certainly they've been a source of income for our practice. We've been very fortunate in that regard.
Yes, finally, and maybe in passing, I wish to place it on record that you were one of those attorneys whose drafting skills I admired. So much so that when I got busier, I took the stance that you would do the drafting and bring the papers to me so that I could settle the notice of motion and any certificate of urgency that had to be filed. Thank you.
Thank
No
you,
further
Judge
questions, ACJ.
Thank you, Judge President. MEC Gade, if you have any question, I give you this opportunity to ask the candidate.
Thank you once more, CJ, and good afternoon to the candidate and good afternoon to the panelists and commissioners. Just one question for me, CJ. Flowing from the questions that have been raised by Judge President and also the CB before us, I would want to check whether have we been exposed to a situation where you have to rule against a piece of a legislation and probably declare it as unconstitutional based on the merits and of the case before you. Because I have observed and also looked into the magnitude of the work that he has done, you have done, and hence the Judge President alluded that you have been given that opportunity earlier on. So surely there could be some of those experiences within the ambit of the law. So I just wanted to check on that.
Yes, Commissioner, if I understand your question correctly, are you saying that, or asking rather, whether I've had an opportunity to pronounce upon the constitutional validity of any legislation?
Yes.
As far as I can recall, not directly in any of the times that I've performed acting stints. I have interpreted legislation or attempted to interpret legislation against the Constitution, or maybe not against the Constitution, but in such a way as to promote the constitutional values. So, for example, in interpreting the Institution of Legal Proceedings Against Certain Organs of State Act or the promotion of access to information, I've attempted to provide an interpretation that is in alignment with the values coming through in the Constitution. But to deal with your question directly, I don't recall having made any order to the effect that any legislation is unconstitutional.
Thank you, MEC Gade. I guess, Mr. Laing, when you say you have had the chance to, or you have attempted to interpret against the Constitution, you mean in line with the Constitution?
Yes, yes. It'll be a better term.
Is that correct?
That's correct.
Okay, all right. Mr. Commissioner Nojesi?
I think this one has some form of confession on my part. One of the things when I went to act Chief Justice I found is the difficulty in writing judgment. I had an introduction that I have to cancel 25 times. It was wrong each time I look on it. I want to find out from you, when you first acted there, did you experience the same thing, or how did you cope?
Yes, Commissioner, I definitely, I've experienced the same thing. It was quite a novel experience to have to adapt to writing a judgment, perhaps not entirely novel in as much as a fairly significant portion or proportion of my practice involves opinion writing. And I think I followed the same principles until a colleague, I think one of the permanent judges, very kindly pointed out an acronym in how to structure a judgment, beginning with an introduction, going on to the facts, dealing with the issues, discussing the legal framework, and then going on to apply that to the facts, rounding up with the relief to be granted, and finally the order. But yes, in a nutshell, it wasn't instant coffee. It came over time.
Yeah, I also had an opportunity of.
One question.
It's the last. This is a very last one. I had an opportunity to appear before you in court. Very impressive, the manner in which you conduct your court, not rude, allowing. What can you say? It's just I want your comment on this: the importance of allowing parties that appear before you to freely express themselves, especially the young practitioners that appear, which you have been doing. What can you comment on?
Thank you, Commissioner, and I really appreciate your comments. I think that what I've had to maybe learn more in time is really to listen to others and to listen to practitioners in particular. Law is not straightforward. It's complicated. It involves a real mix of competing interests, and I've been privileged to have worked with more senior professionals from a diverse range of backgrounds, as I mentioned earlier on, who've helped me to just appreciate the value of approaching a matter with an open mind, and not coming to any conclusion until I'd heard the full story. Every story has a particular shade or tone when it's first presented, and it appears to be this until the other counsel stands up and says, well, no, not really, it's actually like that. And that has helped me just to maybe pause a bit and to really try and listen carefully.
Thank you. Commissioner Teodoro.
Thank you very much, ACJ. Good afternoon, sir.
Good afternoon, Commissioner.
From what the JP was saying and from what we see here, it is quite clear that you support and embrace the transformation of the judiciary. But we have a predicament here. You are male, you are white, and in that sense, in your view, how will your elevation to the bench advance the transformation of the judiciary?
Thank you, Commissioner. I think right at the outset, I would have to concede immediately that as a white male, that on its own doesn't advance transformation. It simply is not in alignment, to use an expression mentioned earlier on, with the constitutional imperative. And I think on reflection, I would simply want to say that if the Commission has regard to the number of years of professional experience that I've been fortunate to have enjoyed, as well as the exposure to a diverse variety of professionals, as well as if the Commission has regard to the nature of my judgments, where I hope that an appreciation and a recognition of constitutional values comes through, then the Commission would possibly consider my skill set and experience to be of some value. The only other thing that maybe I could add to that is to mention how important to me, and I think this possibly attaches itself to Commissioner Nortiesi's question too, how important to me the constitutional value of human dignity is. The need to respect and value the other person for who they are, to recognize and appreciate the road they've traveled to be where they are, maybe simply to recognize the humanity in the other person, and that sense of human dignity and that respect for human dignity, it informs the way in which I interact professionally, it informs the way in which I interact personally. And I hope that's come through in the way in which I've conducted my judicial duties.
Just a small addition, CJ. Don't you think that if you are considered positively, don't you think that to continue to support, to train, especially young legal practitioners, can make an indelible contribution?
Yes.
In that respect?
Yes, most definitely. It most certainly would. At my firm now, we have attempted to continue the practice that I mentioned earlier of focusing on employing Black candidate attorneys and young associates, and I think that's a vital part that can be played in for the sake of transformation of the profession.
Thank you very much, CJ.
Thank you, Commissioner Shabang.
Thank you, CJ. Good afternoon, Mr. Laing.
Good afternoon, Commissioner.
I want to take from the questions, from the answers that you gave the JP, where you said in your firm you adopted the culture of briefing Black counsellors. Out of those Black counsellors, is there women counsellors? And if it's there women counsellors, how many are they? You can give the percentage. If the percentage of Black women counsellors that you are briefing are less than male, are you intending to increase the percentage? And also, since it's a law firm, I heard when you are responding to Councillor Tutu that you are intending to employ more Black attorneys. Have you already started to employ, to have women attorneys that you are grooming? If you do, what is the percentage? Thank you.
Thank you, Commissioner. The precise percentage I wouldn't be able to give to you, but in relation to it may help if I indicate to you in terms of my current matters. There are 8 counsel currently on brief, of whom 5 are Black, and of the total of those 8, I would say there are 3 who are women. In relation to the employment of female attorneys, we to date have only employed Black female candidate attorneys, and would want to continue that. In all honesty, I don't think that we've done enough to promote Black women, but we would certainly want to focus, continue to focus on that in the way going forward.
Thank you for the undertaking, Mr. Laing. Thank you, ACJ.
Thank you, Commissioner Madonsela.
Thank you, ACJ, and good morning, Mr. Laing.
Good afternoon.
Morning. Good afternoon. I've lost. Been living here at 1 o'clock in the morning, 3 o'clock in the morning. Yes. First thing, you make me feel bad because I looked at your CV and I realized you were born on the 13th of August 1970, exactly my birthday.
The same day and year.
Same day and year.
Wow.
So I think I must actually now start thinking about what you are doing.
That's
Secondly,
good
I
news.
want to make
That's good news.
Secondly, I want to make a confession, no, a testimony. You really indeed briefed me in a very big matter, which was very critical for your client, and you briefed me to lead a female black junior who was briefed with me in a matter, and I did not do that matter non-lucre causa. So I just want to give testimony to that and just put it aside.
Thank you, Commissioner.
My question to you is that I think you're not bragging enough. That matter involved procurement law, critical issue which was new. And I see in your CV you're not making the point that I discovered when I consulted you in that matter, that you have actually not only done matters in procurement law, but you have even written academically on that subject matter. And I would like you to talk about that and tell these commissioners what your broad breadth of knowledge is on that topic.
Thank you, Commissioner. Yes, I have engaged with the subject academically. I was very fortunate to have been able to have completed my LLM, my master's degree in public procurement law and policy through the University of Nottingham, especially through the Public Procurement Research Group, which is regarded as a global leader in this particular field. And through that experience, I was privileged to have been able to have been invited to a number of conferences hosted by the Public Procurement Unit at the University of Stellenbosch, and presented papers at both those conferences that I attended. And those papers, in turn, I was most pleased to have been able to have been invited to use the papers as the basis for academic articles that appeared in various publications. The first of those articles was, was to do with the lack of sufficient regulatory guidance, or not guidance, but more of a framework that exists with regard to the deviations from official public procurement processes, and how this led to a very mixed and inconsistent approach by organs of state in deciding when and how to deviate from official procurement processes. So that's the first of the articles. And the second article dealt specifically with a concept known as the standstill period, which in a nutshell is a mechanism to allow an unhappy bidder an opportunity to challenge the award of a tender before the actual implementation of the tender. And that concept features in the Public Procurement Bill. It in fact features quite prominently in the European Union models of public procurement. It's not straightforward. It has certain disadvantages, and I'd hope to be able to have maybe explored the pros and the cons of that mechanism in the articles.
Thank you. It may very well be your lucky day, because you're not only sharing the birthday and month and the year with me, but also with one of the commissioners seated next to me.
Commissioners on the virtual platform, any question? No question for the candidate. I think we have reached the end of this interview. Thank you very much, Mr. Laing. We appreciate that you made yourself available. You are now excused.
Thank you, Acting Chief Justice. It's been a real honor to have been here.
Thank you. Thank you.